Good afternoon. Welcome to Long Live Third Parties podcast. Free Press Media Press Inc., the Third Parties Books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Pisano versus Strach, 743F3D927, Court of Appeals, 4th Circuit, 2014. Friends, we have a purpose, a noble purpose, awesome purpose. So let us advance that purpose today, and that is the purpose of advancing third parties to get ballot access. This case is in the state of North Carolina. Anybody out there from North Carolina? I don't recall ever visiting North Carolina for sure. I traveled down to Florida, and I don't remember if I went through North Carolina or not. But maybe you've been to North Carolina. What's the political scene like there? What's it overall for third parties? Here we see there are some challenges for third parties. So let's read from the record. It says, quote, North Carolina provides 3 ways for a candidate to appear on the general election ballot when running for a partisan federal, state, county, or municipal office. First, a recognized political party may nominate candidates. Second, unaffiliated candidates may petition to appear on a general election ballot. Third, and most relevant here, a new political party may nominate candidates. In this appeal, L. Pisano, Nicholas Triplett, the North Carolina Constitution Party, and the North Carolina Green Party raised an as-applied challenge to the North Carolina's May 17th petition filing deadline for the formation of new political parties. They contend that the deadline violates the First and 14th Amendment because it imposes an unjustified severe burden on their ability to field presidential candidates. They also assert that the deadline violates the Equal Protection Clause of the 14th Amendment because it places an additional substantial burden on them that is not imposed on unaffiliated candidates or recognized political parties. End quote. Once again, like I've been saying in this podcast, our third-party friends love to invoke the First and 14th Amendment. We here at Free Press Media Press Inc. are dedicated to advancing the First Amendment. So we love when the First Amendment combines with the advancement of third parties. And like I always like to say too, the 14th Amendment rocks as well. Thus, in this case, our friends at these two parties, these two very different parties, the Constitution Party and the Green Party, join forces in a coalition to challenge the May 17th date for filing petitions. The court says they didn't challenge another related law for ballot access in North Carolina that requires 2% of voters to sign for the ballot. But they do note when the two are combined, that makes it extra hard. So I ask you, friends, which is a greater difficulty? Is it the deadline or is the amount of signatures? When you gather signatures for ballot access, what experience do you have? My experience was helping the Reform Party, and also when I ran for office for a nonpartisan race, I needed to gather signatures. Fortunately, in my case, it worked out. I didn't need to challenge the law. If I had to do that back then, who knows what would have happened. But fortunately, our friends here are willing to challenge the law when they don't get their rights asserted. Ultimately, they conclude, like they've done in many other cases, that this deadline is fine, it's fair. They say that actually North Carolina is a very lenient state compared to others because it allows almost 4 years, pretty much since the end of one election to the next election, to gather the signatures, where apparently other states have a more restricted time to gather signatures. So ultimately they say the following, quote, for the reasons given, this district court judgment is affirmed. End quote. We didn't lose, but I suppose we can't win them all. Still, fighting is good, and fighting inspires me, and I trust it inspires you as well. So let's keep fighting the good fight of ballot access for third parties. Long live third parties. Goodbye.